Hi, welcome back to my channel. I sent down. I really sincerely apologise for yesterday for any issues involving the channel. For some reason, the touch button on this keyboard is mayhem. It's just so sensitive, and I'm not used to it. But hopefully you can hear me now, and this is for only 21 plus. I am apologise for anybody who saw this who wasn't 21 plus yesterday. I am absolutely not happy, but yeah, I don't know why this. I do say nobody under the age of consent, should know details about cases and extreme. You should be, watching stuff on Forever Nights at Freddy's, wherever, not to do with crime. It's something that it's just at the fingertips of YouTube, and I'm not sure how to. I'm going to do a Patreon account probably, because the details of some of these are really gross. Yesterday I did one on a Nagard, and I wasn't a very expected thing that he was that bad. But anyway, I hope today's easier getting the details up that I wanted to share with you over Shannan Gilbert this time. Okay. I'm back here. It should be. See, my hands are so sensitive as well, stupid, but yeah. This was the one what you couldn't hear last time, and I had some gentlemen point this out to me. I had problems getting it, and I didn't know that nobody could hear what I was saying, so I apologise again, stupid. But yeah, I wanted to read this out, the decision of the order, what was made on the case in 2020. They have a counsel of John Ray on the Gilbert side, and then the defendants, Hackett. Inaction. Inter Ellie to recover damages, and I hope you can see. For the personal injuries and non-party of Suffolk County Police Department appeals from an order of Supreme Court of Shannon, of Supreme Court, Suffolk County, Sanford Neil Burland J, dated October 29, 2018, the order denied the motions of non-party Suffolk County Police Department to quash certain subpoenas granted to those branches of the plaintiff. Okay. So they were trying to not let them see, put restrictions. Cross motion, which were to enforce subpoenas subject to the stated restrictions. Ordered that the order is affirmed with costs. In this action, the representatives of the estate of Shannan Gilbert and her mother Marie Gilbert seeks to recover damages of the defendants Charles Hackett, Peter Hackett, in connection of Shannan's disappearance and death. As a result of the rulings of Supreme Court, the causes of action that remained at the time in the order appealed from As a result of the prior rulings of the Supreme Court, I'll go back. The cause of action was remanded at the time of the order appealed from, which was decided where to recover damages for the Shannan's pain and suffering up to the time of her death, and for the emotional distress related harm suffered by Mary. The plaintiff served non-party Suffolk County Police Department with two court orders subpoenas. First subpoena sought in May of the 6th of 2020. The production of the recording and the transcripts and analysis of the 911 call received and recorded by New York State Police Department, turned over to Suffolk County Police Department. Okay, hang on. Okay, yeah, because during the call, she gets through to the State Police Department, and they turn it over to the Suffolk County Police because of where she was. Because she does say she's in Jones Island, something. I remember now. So that's what happens during that call. Shannan made on the night of her disappearance on May 2010 the second subpoenas to saw production of any and all recordings of any and all 911 calls made on or about 1st through to the 3rd of 2010 regarding Shannan, as well as the transcripts and analysis of those calls. The SCPD made 2 motions to quash subpoenas, contended that the subpoenas saw production of the records that were barred from the production under the Public Officers Law. The plaintiffs cross-moved, in effect, to compel compliance with the 2 subpoenas. Supreme Court denied Suffolk County Police Department's motions to quash and granted the breaches of the plaintiff cross motion and to enforce the subpoenas subject to stated restrictions. The Suffolk County Police Department's appeals. The discovery provisions of the CPLR Article 31 operate independently of the Freedom of Information Law, and litigants' entitlement to particular evidentiary item under Article 31 is not affected by the disclosability of an item under FOIL. I don't know what that means, but these laws are really worth looking up, and I will possibly do that to get more insight of what the decisions. Disclosure of the civil actions is generally governed by the CPLR 310A, which provides that here shall be full disclosure of all matter material necessary of what was necessary. So this is over the 911 call. I'll turn the paperwork for that. What I found on, and I can't remember if I saved it or what, but I'm going to have a look. No way. No, it's not to do with that. I can't get it up now. But it was the one I was reading out to you, but just having a little search just for something. See, these things aren't easy to find. Sometimes I have to spend hours. No. I'm wondering how I'm going to find it. I'm sure it was on AI I looked up, and it gave me something. It just gives you some links, sometimes. Okay. I mean, her autopsy was undetermined, stuff like this. What conclusions they come to in the end about the decision they made. AI is telling us, I'll share this if you like. Filing in November of 2012, Shannan mother filed a wrongful death and negligence lawsuit against Dr. Hackett. The suit claimed Hackett involuntarily drugged Shannan and released her while she was in a helpless state. Case development over the years. Some claims in the lawsuit were dismissed. By 2017, remaining causes of action focused on the damages of Shannan Gilbert's pain and suffering, but before her death and the emotional distress suffered by her mother. In 2020, the Appellate Court ruled against the Suffolk County Police Department and forced to release the phone calls and related materials to the Shannan Gilbert family, enforced by John Ray. Status in a December 2024 Reddit post confirmed the lawsuit was still ongoing, with multiple new motions filed that same month. Hackett's stance. Dr. Hackett has consistently denied any involvement. Although he admitted to calling her mother initially, denying it, he was questioned by police in an investigation, but was not charged later. Okay. That's the thing I was reading now. I can't find it. For those seeking legal records, search may involve various legal databases, court websites, and data request of the New York State Courts, where the case was heard. Tell us the law. Search for documents. A search using this case name on legal database like Justice Law or Case Mine, that's the one. Not giving me any link though. Am I gonna go in like a normal person? Okay, I'm gonna look on the internet like a normal person. Right, that was the turnover. It's not the one. No. Wow, I freaking hate that fish tank all about my head here. Gonna put something on in the background. I'm watching Professor Dave. It's interesting.
So, if I ask,
this
what are the backgrounds to that? Well, if you have one rule, it turns into two bodies.
Yeah, babe. Right? Anyone can see that, I hope. Let's go, let's read it out. Upon reading this filing, the following papers in this matter, the cross motion of the defendant dated 27th of May 2016 and the supporting papers 2 answering affidavits made by plaintiff dated August 30th 2016 and supporting papers, it is ordered that the motion incorrectly denominated as a cross motion made by defendant Charles Hackett, seeking summary judgment pursuant CPLR 3212, hereby denied without prejudice with a renewal of discovery completed in this action, and is further ordered that the branch of motion made by the plaintiff seeking disqualifies James O'Rourke for defendant Hackett due to conflict of interest hereby, and it is further because he was also his son's solicitor, ordered that the remaining branches are hereby referred to as a compliance conference, and it is further ordered that the parties are directed to appear for a compliance conference on Tuesday, January 30th, 2018 at 9:30 in Part 6 of this court located at 1 Court Street in Riverhead, New York. This is an action by representatives of the estate respectfully of Shannan Gilbert and of their mother Mary Gilbert, seeking damages for the descendants Shannan Gilbert's pain, suffering and death, and emotional distress and related harms suffered by Mary Gilbert. Such a tragedy story, it really is. Suffering, death, and emotional distress related harm suffered by Mary Gilbert. Shannan Gilbert disappeared, and also a sister. You know, I reckon she's so suffering and she's so strong and resilient and getting through it. If she has good support. The plaintiff claimed that Shannan's belongings were found approximately 30 yards behind her home. Okay? Of the defendant, Dr. Peter Hackett, in Oak Beach, New York, on Jones Beach Island, More than a year later, Shannan's badly decomposed body was discovered, approximately half a mile from there. Okay, in heavily thicketted marsh that lies between Oak Beach and Ocean Parkway. During the evening prior to her disappearance, Shannon reportedly had been present at a party at the home of one of Dr. Hackett's Oak Beach neighbours. Okay. The action was originally brought by Mary Gilbert, both individually and as an administrative of her daughter Shannon's estate. Mary Gilbert was killed on the 23rd of July 2016. The subsequently appointed administrations of Shannon's estate and Ministry of State were substituted as plaintiffs. Of the verified complaints, 15 alleged causes of action, those seeking damages of wrongful death, and second, fourth, and fifth, and sixth, and eighth causes of action on intentional tort, and 10th through to 15th causes of action and portions of 5th and 6th causes of action were dismissed by defendants' prior motion for having been brought beyond the applicable statutes of limitation in a decision and order by the court dated and centered December 10th of 2013. The action has been the subject of much additional motion practice, with four motions still outstanding. At a conference held on the 30th of October 2017 before the court, it was agreed that the court would address motion sequence 005, which seeks, among other things, order to disqualify the defendant's attorney, which seeks to summary judgment dismissing the action out of order and render its decision on the motions before addressing remaining motions. Because if, I don't understand, but it's to do with the solicitor, the court's determination of those motions is as follows. Disqualification. Plaintiff seeks to disqualify defendant attorney O'Rourke from also representing the defendant's son, Charles Hackett, based upon alleged inconsistencies between Charles' deposition testimony and that of his father. The disqualification of an attorney is a matter that rests with the second discretion of the court. Okay. A party's right to be represented by counsel of his or her own choosing is valued right, which will not be superseded absent a clear showing that disqualification is warranted. So that means possibly still ongoing. Here, plaintiffs have failed to meet their burden of showing that disqualification warranted based upon the purported conflict of interest. This relief requested in the plaintiff's notice of the motion and in the opening paragraphs of the plaintiff's attorney's supporting affirmation. Elsewhere in his affirmation, however, plaintiff's attorney broadens his request to seek to disqualify Mr. O'Rourke from representing Dr. Hackett's wife and daughter, as well as his son. Here, the plaintiffs have failed to meet their burden of showing disqualification is warranted based on the purported conflict of interests. Plaintiffs' mere conclusionary assertions that there may be a conflict of interest based solely upon the alleged inconsistencies between the testimony of the defendant and that of a non-party family member are insufficient to warrant the disqualification of Mr. O'Rourke. Accordingly, the breach of the plaintiff's motion is hereby denied. Summary judgment. The plaintiff's remaining causes of action are survival claims, in brackets, alleging medical malpractice, negligence and gross negligence, breach of fiduciary duty, and fraudulent inducement. The gravement of all of those claims, as well as those previously dismissed as the time barred, is plaintiff's allegation that prior to the disappearance, in the early morning hours of the 1st of the 10th, Shannan Gilbert came under control and care of the defendant, doctor of osteopathy licensed to practice medicine in the state of New York. Plaintiffs claim that Dr. Hackett led Shannan and later her mother, Mary Gilbert, to believe that he owned and operated a home for wayward females out of his Oak Beach home, and that he would render aid to her there. According medical treatment, that Shannan in fact came under Dr. Hackett's care and control and was administered medications by him. This is what John Ray's testimony is. Dr. Hackett's care and control and was administered medication by him. That Shannan was in such a state of confusion and mental derangement at that time that she was incapable of making any informed decisions and of understanding her own or her surrounding circumstances, and that Dr. Hackett's treatment of Shannan not only was coerced, but rendered grossly negligently, reckless and willfully and in reckless disregard of Shannan's life and safety. Plaintiffs further claim that addition to the obligations stemming from the physician-patient relationship that they allege existed between Dr. Hackett and Shannan Gilbert, or which was imposed upon her by virtue of the control he exercised over Shannan, and the representations he made to her and to her mother. Dr. Hackett also had a duty of care to protect Shannan Gilbert and keep her safe from harm, and to call the police or 911. He had a duty to, yes, and to protect Shannan Gilbert, which Dr. Hackett failed and refused to do. Plaintiffs claim that as a result of Dr. Hackett's alleged misrepresentations, tortious acts, and breaches of trust and duties, Shannan Gilbert experienced pain and suffering and agony, acknowledged and fear for her imminent death, and her in their general allegations, as well as in the specific context of two of their subsequently dismissed courses of action, and perhaps at least partly in anticipation of potential gaps in their proof. Plaintiff also alleges that Dr. Hackett engaged in conduct to conceal thwart discovery of his alleged treatment of Shannan Gilbert, including attempting to thwart discovery of her body, which they claim frustrated, delayed, and blocked the determination of her cause of death. Dr. Hackett has denied all material allegations of the complaint because he refused to have it chopped down, even by the council at the time. So it looks suspicious in itself, doesn't it? The current motion of the defendant seeking summary judgment pursuant to CPLR 32112 is based upon the contentions. First, Dr. Hackett contends that although at times he rendered first aid assistance to a neighbour, he has never conducted a medical practice out of his Oak Beach home. This is what he's saying. This is what he's saying in defense of himself. Please write in the comments any questions you have about the case. Please subscribe. I notice that I see a lot of people coming back here, and I really value that. Just subscribe, because I will get into this, and there's a lot of unanswered questions. There's a lot of on my channel about indictments, when you sort of first find out about someone's undesirable behaviour. I sort of read all that out, but it's not very good for my channel, and I'm going to have to do like a Patreon, PayPal, come in, and I'll read all these out, because a lot of this is detailed, and I don't want to be discreditory to people and make them feel awful about listening to this stuff. Injustices, people who passed away before getting answers to the daughter, passing away before them. It's such a sad case, and unnecessary by Hackett for all this time, and he knew the body was there. The current motion of the defendant seeking summary judgment is based upon two contentions. First, Dr. Hackett contends that although at times he rendered first aid to his neighbours, like sewing your finger back on, giving them cough syrup, he also had allegations of handing Oxycontin out. But you know what? It's doctor. That's not the point. I'll be honest as well. In the testimony, he mentions a lot of people that Hackett happened to be around when they passed away. So I'm wondering if there's cases that you just can't put your finger on. We had a case in England, like Dr. Shipman, and he was a actual doctor. And in the end, he was murdering people to get the wills and all that. He murdered over 112 people, something like that. So yeah, Being a doctor doesn't give you authority to give drugs to a child, to a girl who seems to be hysterical and not report it to the police. I find that really strange.
Well, first of all, thanks for having me. It's a great pleasure. So yeah, this is supposed to be an overview.
He has never conducted a medical practice out of his own beach. He has never been or held himself out to be an owner or operator of a home for wayward girls. He has never met Shannan or had any interaction with her, has never administered any aid or medical treatment to her, and has never observed, concealed, or moved her body. Second, he contends that notwithstanding a large volume of information available to the plaintiffs, including extensive discovery they have conducted since this action was commenced, plaintiff cannot establish that he had anything to do with the descendant Gilbert's death by negligently administering her medication. You know, well, sometimes I think he's a Long Island killer. I really do. In support of his first contention, he was proved this agreement. My eyes go funny. Barbara Hackett and of his 2 adult children, each of whom that their home was not operated as a wayward home for girls. Not present there at any time in the period leading up to her reported disappearance or in the days that followed. In support of his second contention, he provides the transcript of May 28th, 2014 deposition of Mary Gilbert, which he asserts further establishes that the plaintiffs are without cognizable evidence to support their allegations of his involvement in Shannan's alleged treatments and responsibility for her death. On those bases, he argues that he is entitled to a summary judgment dismissing the remaining causes of the complaint. Although the opening portion of Dr. Hackett's attorney's supporting affirmation seems to suggest that the defendant's motion for summary judgment is directed at the complaint's previous dismissed wrongful death cause of action, his arguments are clearly directed at the remaining cause of action. The prayer for relief explicitly requests that the complaint be dismissed in its entirety, and it does not appear that the plaintiff's counsel, whose opposing papers are ample, was misled as to the breadth of the relief sought by the defendant, or prejudiced in his response. Plaintiffs oppose the motion on the grounds that such of references deposition testimony of Mary Gilbert is misstated in defendant's motion papers, and that her testimony, along with a good deal of other evidentiary material, actually demonstrates that there are indeed terrible issues of fact that render summary judgments inappropriate. Thus, in addition to providing the transcript of my eyes are going. I'm just going to have an eye break. I don't know why I need glasses. Went really fuzzy. I'm just gonna smoke. But yeah, I'll read out. I'm not sure how long it is, but I've got a bit of time. Yeah.
And these principles are just essentially the principles of quantum mechanics and relativity. So essentially, there is no other way of having
Just 4 or 5 minutes. I'm going to have a little break.
this qualitatively the broad structure. Right? Quantum relativistic quantum field theory, including gravity, so including general relativity, in a way that of course it's not a clean, complete theory, but it's an approximate theory that works at low energies, low resolution. It's essentially inevitable to get this kind of thing when one begins with very solid, well-established, principles of quantum mechanics and relativity. And this has been documented several times. And here I'm putting like this screenshot of one of the many seminars that Nima Kanyana that you can find. And this is one of the people who actually really emphasizes this, that this kind of framework for physics within at least the range of accessible energy so far.
Because she's no longer here as well, it doesn't feel like there's much to go by this, but it's one of those cases like you've got to look into and think, oh, it's such a difficult, ground to talk to. I'll be honest, the Long Island Sea go now is looking more like individuals dumping there, but I'm not sure. But we hope for answers, and more discourse, about it, the better, Let's not forget, as a kind of human, his uncle, who was a priest, admired and idol in the church, what he did to children, videoing them, taking the clothes off, assaulting them, molesting them. This is the man, Rex Human's uncle. He had a grandfather who joined the Apollo missions as well, Very connected family.
That math is at least one way to describe this physics. The point is that the principles are physics. This is what I really want to emphasize. I mean, here, for example, in this screenshot at this particular time is emphasizing how this is information. He was explaining how the boson is essentially energy. Like the community really decades before the discovery understood that it was needed to save one of the principles of quantum mechanics from breaking down, right? In entirety, the conservation of probability. So, and one of the things that he emphasizes as a point of this reference is that the procedure of just changing the rules of the game from fun or the reason never actually worked. The way that physics, theoretical fundamental physics progressed has always been by understanding, the deeper reasoning behind some refinements of the principles, never actually just throwing things out and starting new. Let's modify gravity, let's change quantum mechanics. Of course, there are people who try to do that, and I'm not saying you shouldn't, but to do that, I think, it's a good example seems to be enough of changing the quantum mechanics and something like that. Now, my position, and I think is that there is no evidence that this is necessary. Quantum mechanics seems to work perfectly, and even the conceptual aspects that are debated can be solved, or at least argued to have an answer within quantum mechanics itself. Right? And let's say, even if one did modify quantum mechanics in a way that somehow reduced well understood established reasons.
I'm sorry. My eyes are a little bit messy at the minute with me having hay fever tablets, it must be. Okay. Right, I'll have a sip of me coffee. Hope everyone's having a good day. I've just took my daughter to school, first day back. I'm wishing her luck and everybody else's families who it's hard when they first go back the first day, even if they're still in the same school, they get nervous, don't they? So I wish everyone well. Plaintiff opposes the motion on the grounds that so much of a reference deposition testimony of Mary Gilbert is misstated in defendant's motion papers, and that her testimony, along with a good deal of other evidentiary material, actually demonstrates that there are indeed triable issues of fact that render summary judgments inappropriate. Thus, in addition to providing the transcript of an undertaking to rectify the asserted misstatements by defendant of Mary Gilbert's deposition testimony, plaintiff submits Miss Gilbert's prior affidavit made on 28th of March 2013, recounting 2 phone calls she received, one on May 3rd, 2010, 2 days after Shannan disappeared. Okay. And the other several days later, the 6th of May 2010. I reckon he had some kind of relationship with her, and he liked her in some aspect, and I don't know what's going on. You know, I really don't. I don't know if he's guilty or not, or he knew of it and he couldn't say anything. More likely. On the 3rd of 2010, 2 days after Shannan disappeared, and the other several days later, on the 6th of May 2010, from a man who identified himself as Dr. Charles Hackett, and who, among other things, told her that operated a home, halfway house for wayward girls, that Shannan had been in his house on the 1st of May 2010, and that he had tried to help her and get her treated, but she left with her driver and he was worried about her disappearance. Telephone records show that calls were placed from Dr. Hackett's cell phone and from his home phone on both dates, to Mary Gilbert's cell phone. So there was proof that he did phone her. You know, why would she lie? And the latter day from Dr. Hackett's home phone number to Shannan's sister's Sherry. I'm not sure if that's the one who's not in prison. Miss Saloni of affidavits and signed statements made by several of Dr. Hackett's beach neighbours who claim either to have seen, told by other neighbours that Shannan was present at Dr. Hackett's home or was given medication by him that night, the night of her disappearance of the reporting. At first or second hand statements made by Dr. Hackett admitting that he had done so, including one individual who claims he overheard from his car as he drove past Mr. Hackett's residence, Dr. Hackett frolicking against the siding of his house and wailing to his wife that he couldn't believe the situation he had put the family in, and that his intentions was to help SJ, not to kill her. There is also an affidavit of one attorney recounting conversation that he had with Jersey City, New Jersey police detective who, according to the affidavit, told him that Dr. Hackett had called him within a week after Shannan Gilbert went missing and told him he operates a home for wayward girls. So it all adds up what Mary Gilbert was saying, you know? This is why it's good to read everything. It still doesn't give us any substantial lead to a conclusion by any means, but to me this is quite damning, you know. On motion for summary judgments on moving bears and initial burden and must tender evidence sufficient to eliminate all material issues of fact. Okay. Once the movement meets this burden, the burden then shifts to opposing party to demonstrate that there are material issues of fact. Mere conclusion and unsubstantiated allegations are insufficient to raise as issues of fact. Okay, that's what they're going with. So they're saying that him saying that he ran a home for wayward girls and stuff is just nonsense, basically, as a court functions on such motion to determine whether the issue of fact exists, not to resolve the issue of fact or to determine matters of credibility. The facts alleged by the opposing party and all inference that may be drawn are to be accepted as truth. Okay. So it's an agreement that he is telling, substantiated by evidence of other people saying it, that what Mrs. Gilbert was saying, it's, noted. As noted above, the plaintiff's remaining claims are survival claims seeking damages for Shannan's pain and suffering at the time of death. Although a variety of torts and theories, including medical malpractice, negligence and fraudulent inducements are alleged, each is rooted to varying extents. Okay, it is, yeah. In the plaintiff's allegations that Shannan came under Dr. Hackett's care or control, and that his actions or inactions led to her injuries, thus prevail. Ultimately, in this action, plaintiffs will have to sustain their burden of proof with respect to each of the elements of at least one of the causes of action they have alleged, no matter what the theory. Proximate cause. At this juncture, however, I don't know what's missing there. Don't like that. However, in the face of Dr. Hackett's categorical denial of any contact with Shannan Gilbert whatsoever, much less having exercised any control over her or having rendered any treatment to her, supported by his own sworn statements of those of his wife and children, which is sufficient to establish a prima facie of elements on his part to summary judgment. Plaintiffs need only show that there are material issues of fact that prevent summary disposition of their claims. Plaintiffs' opposing submissions, including in particular the deposition testimony of Mary Gilbert and the affidavits of Bruce Anderson, and the statements of Joseph Sellers, each of whom represents that Dr. House either stated directly or, in the case of Mr. Scalise, within his hearing, that he had brought Shannan Gilbert into his home and treated her with medication prior to her disappearance on the 1st of May. He should just admit it if that was the case, but why isn't he admitting it? There's systematic to this homicide. There's medication, there's sedation, there's keeping people, torturing people. He kept Jennifer for days, 4 days at least. Dr. Hackett's first contention that he had no contact with Shannan whatsoever. What was I reading down? I forgot. Shannan Gilbert into his home and treated her with medication prior to the disappearance are plainly sufficient to raise triable issues of fact with respect to Dr. Hackett's contentions that he had no contact with Shannan, never heard of her in his home, and never treated her. Although plaintiff's counsel describes in an affidavit handwritten document bearing the date of 24th of July 2007, signed by Scalise before notary and with witness on the 24th of 2016, and bearing the same date, there is no indication that Miss Scalise was under oath or otherwise sworn at above before the time of the signed paper. Although the plaintiffs have raised triable issues with respect to the defendant's first contention, the sufficiency of their opposing submissions with respect to the defendant's second contention, that the plaintiffs cannot show either Dr. Hackett alleged conducted and or inaction violated any applicable standard of care, or that anything he did or did not do was a proximate cause of Shannan Gilbert's death or of any injuries sustained by her. However, present such closer in question, plaintiffs concede that they have no first-hand knowledge of Shannan Gilbert's death and are relying on Mary Gilbert's claimed Dr. Hackett that had told her information provided by another witness. Neither Dr. Hackett alleged statements to Mary Gilbert nor the information provided by any other individuals they cite, however, shows demonstratively culpable conduct on the part of Dr. Hackett in connection with his alleged contact with the treatment of Shannan Gilbert, or a sufficiency counsel connection between such alleged contact and treatment of Shannan Gilbert's injuries and death. Plaintiffs offer a number of theoretical scenarios to counter the defense's second contention, in particular that Dr. Hackett, I'm just having a little break.
Many directions that people investigate how to reproduce the correct particles what that matter can
took Shannan into his home and, without following proper medical procedure, such as notifying the proper authorities and summoning an ambulance, imprudently administered medication to her, which is in itself a no-no. When she became hysterical, let her wander into the marsh where, disorientated, she became lost. This is in 2017, by the way. Okay? This quote. Let her wander into the marsh. Disorientated, she became lost, and perhaps after falling, hitting her head, and suffering intracranial bleeding, she suffered the effects of exposure and perished. An outcome that could even then have been averted had Dr. Hackett prompted a more immediate and better directed search for Shannan and not withheld his knowledge of her likely whereabouts. Disgusting, isn't it? I mean, a doctor not phoning the police, a bit weird. At this conjuncture, however, that scenario, as well as the others offered by the plaintiffs, depend on a chain of inference bordering on speculation. Okay, and especially because as a result of a lengthy delay in finding Shannan's remains, the precise cause of her death has not been determined. That's about savage, isn't it? So they're saying the plaintiff was so determined on Dr. Hackett that he just wouldn't let it go. It would be noted that although the plaintiff have asserted claims alleging medical malpractice against Dr. Hackett, it does not appear their complaint was accompanied by certified required CPLR. Okay, nor do their current papers include any affidavit affirmation or other statement from any appropriately credentialed individual attesting that Dr. Hackett's alleged treatment of Shannan Gilbert departed from the applicable professional standard of care. In recognition of her current difficulties in proof, plaintiffs citing the Court of Appeal decision in and states another law case and its asked the court to apply a relaxed standard of proof in their claims and to give more weight to the circumstantial evidence. In noteworthy, the Court of Appeals held that it was an error for the trial court in an action in which the plaintiff's descendant had been struck and killed by a subway train, and the train's motorman was the only witness to the accident. To refuse to instruct the jury in a death case such as this, that the plaintiff is not held to the high degree of proof required in a case where the injured person may take the stand and give his version of a happening of an accident. Noting the attend to recent cases to expand the relaxation on the plaintiff's burden beyond the issue of contributory negligence and to the full elements of the plaintiff's cause of action itself. The court, quoting from its early decision on another case, explains.
high energy physics be somehow fixed, and it is, except it's too hard to probe directly. But then the low energy physics, the low energy predictions, should only be, fixed once you choose a vacuum for a low energy, phase of the theory, of which there are many. As I said, not a physics problem; it's a physics problem. And this is exactly what the case is here. So maybe what people really would like is low energy predictions that we can access, but that do not depend on the specific choice of vacuum, right? That are universal and will teach you regardless.
The analogy to a noteworthy line of cases is less than perfect here, particularly in the current state of the record. Among other things, whether or not Dr. Hackett was an eyewitness to the events leading to Shannan Gilbert's disappearance, and the death in itself a question of fact. And although a noteworthy relaxation of the burden of proof has been applied where there is no surviving eyewitness to the event, holding that here is a less stringent evidentiary standard applied in wrongful death cases. Particularly, there is no witness to the accident. It is still an incumbent upon the plaintiffs to proffer sufficient evidence, circumstantial or otherwise, to take their claim that Dr. Hackett engaged in tortious conduct that was proximately cause of actionable injury to Shannan Gilbert. From the realm of the insufficient speculation to reasonable inference. Again, the question of whether the plaintiff can do so is, on the current record, a close one. Given, however, that discovery included the depositions of various Oak Beach residents, human knowledge potentially relevant to the parties' claims and defense of this action is attributed in the submitted statements of other residents, is yet to be completed, and has been stayed as a result of filing defendants, is yet to be completed, and has been motion of summary judgment. The appropriate course is to delay the motion without prejudice to renewal after the remaining discovery has been complete. According to the defendant's summary judgments in his favour, dismissing the remaining cause of action asserted against him is denied without prejudice to renewal after the completion of all discovery. The parties have remained aforementioned compliance conference, the 30th of January 2018. This was done. Okay. I just wanted to read this off. I want to try and get an up-to-date version. Okay.
Stuff down, we complete stuff, like there are things we're gonna feel. There's none of that, right? There's nothing.
Okay. Sorry. Bit of art showing time, huh? Maybe a little break. Okay. I've been painting this one. Do you like it? I haven't yet completed the background, but I want that colour, you know. I've been working on my Turner, my inner Turner instinct. Do you like it? It's cool, isn't it? Still to complete this one, you know. It's that way. Can you see? It's it's just a Gucci throw over. I just got that out of a magazine, you know. I do like this one, but I don't know. Not to everyone's taste, you know. But yeah, I like to do lots of sort of pictures. I'll show you just a few because I've got too many. I'm prolific. I elevate anything Egyptian. I did that for 4 hours. It was my daughter. Just did it with pencil and all that. She has a throw over her head because she's got light sensitivity, and yeah. Yeah. I'm yet to do one of my youngest daughter, but yeah, I'm going on it. I'm doing it. You know, I have fun. You know, it's got what it's about, isn't it? This is a little bit of my time looking up documentation and things of that nature. I do feel like the more I get told, the more confused I get about the case. But I do feel after reading that I feel that Shannan went to his area, took something, ended up with Brewer, and the situation just changed for her. She sounded lucid. She sounded more lucid than me. I take medication, so I don't sound lucid ever. But you know, it's sad because I just want more answers for us. I don't think Hackett is involved, but then at the same time, I do. I'm ambivalent. I'm still like that. You know, is he? What do you guys think? It just seems too strange that he was right by the bodies as well. That man committing suicide. You know, and then this about Shannan. You know. Maybe there was two situations. I mean, kind of human as actions. You know, reading that about the victim. I don't want to name any victim, so you read it and you think, is this going on? Is this just satanic panic? Why is it Rex Human is a serial killer? You know, he's charged with 7 murders so far with his and it's all resting today on his case. But I would like to know, was there any DNA found in the Shannan Gilbert case, and what can we prove that it was accidental death? Because it doesn't seem possible. Just doesn't. But then I didn't see the area at the time. You know, when you're hysterical, what type of steer was she running from? Got to ask yourself. If a cliff was there, she probably would have went over it. Why? What was going on for her to feel like that? There was something of substance here that we just haven't got answers to. And even if you've got speculation and things like that, or you know the truth, please come forward and speak. You know, your truth is valued no matter what situation. I do feel this family knew. Rex Human's family knew. What could they do about it? One evil's better than another evil to you know, maybe the man she married the first time was a paedophile or something like that, and she met Human, and he, you know, yeah, he likes to have prostitutes and all the rest of it, but you know, and then Karen Vergata goes missing. Jennifer, Sandra Costello, people like that, and the timeline, it's like, and until like therefore, it's like he didn't want to get caught, so he did it. But these, they were different. These were different, you know. It's funny that his granddad was an FBI agent, but he had like Mind Hunter on his table. It's written by an FBI agent, isn't it? It's written in a very manly perspective, you know. No women in the FBI back then, you know, stuff like that. He's got real derogative family history. Do you understand me? It's like obvious they don't value women, and it's not hereditary. It's more what you've been told what was normal in your life as a child. You know, I knew violence was wrong, and as a child, you know, as he's grown old, he's grown bigger, stronger, and got a successful life. But there isn't enough. He's got to fulfill what's there in his soul, his deep-rooted desires, and that is the sensation of killing somebody, like of a work profession of that nature or any nature. Or if she give him a bad like look or something, or you know, she served him coffee, and how do you know that these women he'd stalked them? He may have stalked these girls, you know. What's interesting to me is the fact that, like, what AI reminded me of there is, oh God, what did it remind me of? I absolutely, I miss. Sorry, shouldn't I? But yeah, I'm going to have a look back and see much more in detail, and I hope that, and I haven't bored you too much to death today. But God bless and take care.